Yes, hello all. First of all, thanks to the organizers for giving me opportunity to speak on teaching of international trade and economic law. This topic is very close to my heart because being teacher since last 10 years, I am teaching this particular subject. First of all, let me introduce myself. My name is Dr. Rashmi Salpekar. I am the professor and dean at Vivekananda School of Law and Legal Studies, Vivekananda Institute of Professional Studies, which is an affiliate institute of Guru Govind Indraprastha University, Delhi. I have done my doctorate research in international law, and mainly it is on individual responsibility under international criminal law. However, I have received all the opportunities to teach mainly international trade and economic law. So thereby, fortunately, with the blessings of my teachers, I got opportunities to teach various branches of public international law. So being postgraduate in international law, doctorate research in international law, and further I am teaching various branches of public international law. In that also mainly I am teaching international trade, economic and international investment law as well. My publications are also mainly on international law, even though I feel that being a lawyer or being law academician, we have to do something for our social problems as well. So therefore, a few empirical projects, funded empirical projects also I have done in this particular academic career. So with this brief introduction, let us start teaching of international trade and economic law. Now, first of all, if you will see our teaching, then according to me, teaching is a profession which is one of the best profession. In fact, it has a lot of importance, and therefore there is a special position to this particular profession. In this, we teachers need to teach various subjects and its dimensions, and law being a normative science, it demands teaching more specific, focused and critical in nature. One of the aim of law teachers is to create critical thinking capacity among students. So therefore, this is our main objective, that we are required to create a critical thinking capacity, that particular attitude amongst our students. Each subject has its own nature, and thus it is always advisable to understand the teaching technique to teach a particular area or a particular subject. In public international law, there are various branches, and one of the important branch is international trade and economic law. Now, why it is very important? It is very important because at present, trade and economics is not only connected with human rights, humanitarian and criminal law, but in fact it is overpowering other branches as well. You will find that not only military war, but in fact economic war is also creating problems for the society at large. And military war may be limited only up to one area, but however economic war, it's what we say that its reflections you will find across the world. So therefore, international trade and economic law is very important to understand for law students. Thus, there is a great responsibility on international trade and economic law faculty members as well. Now, coming on this trade and economic law, we all are law teachers, so we are aware that this particular subject you will find only by name of international trade law is the part of curriculum, or maybe international economic law is a part, it is one of the subject in our curriculum. At times, it is known as international trade and economic law as well. Bar Council of India has also incorporated international trade law, international economic law in its basket, which they have given under Bar Council of India legal education rules. So it is, this particular subject has that particular position. this particular subject, that is international trade and economic law, you will not find that any university has prescribed in its initial years of law program. Law program, it is of 5 years or 3 years. So you will find that mainly in senior semesters or senior years, this particular subject is given. So thus, our target group, when we are teaching international trade and economic law, so our target group, so they are the students who are of the age of as good as they are of postgraduate students, right? In addition to this, as they are of the senior semester students, so therefore already they have done their basic subjects. They have that particular understanding about law as well. So therefore, we can take it as a specialized subject for students. So while teaching international trade and economic law, I would like to suggest that we should keep in our mind one simple equation, that is, or we can call it as a process, that is known to unknown. Now, as I have told you that students must have done earlier various subjects, in that they must have done even public international law as well. To teach and to understand international trade and economic law, first of all, we must be aware about the basic concepts of public international law. And this particular demand you must keep from students as well. So therefore, whenever this particular subject is allocated to you, first of all, you just try to understand that how far your target group is aware about public international law. Basic things like what are the subjects of public international law, what is the relationship between international law and municipal law, as also sources of international law. So these few basic things, all of us, when we are aspiring to teach international trade law, or when students are there to understand international trade and economic law, they must be aware. So in initial classes, you please check it that how far your target group is aware about it. If not, then yes, at least spend 1 or 2 classes so that you can bring your target group to understand international trade and economic law. Further, you please also explore that how far they are aware about trade and economics, how far they are aware about market, how far they are aware about imports and exports, how far they are aware that what or how the impact is coming up because of the political relations or because of the international relations, how that impact is coming on the market as also on the customers as well. There is a misnomer that trade and economic law is something which state is required to understand, government is required to understand, but it is not like that. Whatever we are paying for petrol, for oil, for gas, it is all because of trade and economic relations, right? So it is not only up to the government policies, but it is you and me also who are the actors under international trade and economic law. Now, actors means, don't take this particular word theoretically, because in international law, subjects are also called as actors. In fact, if you will read international economic law mainly, then there are various actors. So here I mean by that even you and me, we also deal with international trade and economic law. So that particular connectivity we are required to explore in the class. So in initial classes, please check whether your students, they are aware about public international law basics, and also just try to understand that how far they understand this particular process of trade and economic law. I always advise to all faculty, and I also do the same, that once you start subject, first of all you please tell them the list of books or articles to be referred. Here I won't give you a long list of books and articles. Why? Because there is a special value to the recent publications, right? Even though we always need classic textbooks in any of the subject, but recent decisions or recent article publications in various journals, it has its own value. Why? Because these articles, they always come up with contemporary issues and contemporary problems. They analyze it. But in literature, I would like to quote few of the authors. Now before that, first of all, let's see that what is the title of the book. Now why I am telling you, because in trade and economic law, in Indian universities mainly, I have seen in the syllabus, under international trade law, this particular title, you will find that mainly we are dealing with WTO, that is World Trade Organization, which is one of the organization who is regulating and promoting international trade, right? But however, in the books published in foreign universities or foreign professors, under the title of international trade law, they have dealt with international commercial law as well. Now here, what exactly is all about? Now trade is there between states or among states. This is one. Another type is that wherein one multinational corporation is dealing with another multinational corporation, or one transnational company is dealing with another transnational or MNC, or with an individual, right? So when they are coming into a contract, then these kind of relations, that how they are coming into contract, then how they are sending their goods, how that particular consignment is reaching to, whether it is reaching at port or airport. So all these things comes under international commercial law as per the syllabus which we generally see in India. But however, there are few books wherein the title is international trade law, but the transactions which are taking place on individual basis. So for that matter, the legal regime, what we generally called as international commercial law, so that you will find in that particular book. Okay, so don't go by title. You please read the contents whenever you are selecting a book to be referred to your students. Now in that, we should we should take name of a few books, like for example, a book written by Lowenfeld. This is one of the classic textbook, right? And the name of that particular book is International Economic Law. His complete name is Andreas F. Lowenfeld. He has given comprehensive analysis of the legal foundations of the international economy. Now in this book, you will find that there is International Economic Law. This is the title. So the parts are International Monetary Law, International Trade Law, International Investment Law, International Environmental Law, as also Development Law. Okay, so these are various parts you will find in one book. This is a classic textbook. Further, book by John H. Jackson, that is World Trade and the Law of GATT, is another book to be referred. It gives us answers of all why, that why GATT is there, why these provisions are there. So for that particular matter, you will find that the best book is John H. Jackson. No one can deny his contribution in the development of international trade law. So yes, we should read at least once, and in fact this particular book should be referred as a textbook to your students, that is book written by John H. Jackson. Further, if you wanted to have some kind of flavor that what exactly is going on in this contemporary times and how the foreign policies are going on, mainly of United States. So in that case, we should refer book written by Professor Raj Bhalla. His book, that is International Trade Law, Interdisciplinary Theory and Practice, is one of the well-known book on international trade law. So I will suggest to go through this particular book as well. And what about the contribution given by our Indian scholars? There are various Indian scholars who have given great contribution in international trade and economic law. To begin with, Professor A.K. Kaul. His doctoral research was on UNCTAD, that is United Nations Conference on Trade and Development. Further, he developed that particular doctoral thesis into a book, as far as my information, and that book is titled as UNCTAD. I have read many times this particular book, and I would suggest that this book also can be recommended to students. Then further, Professor B.S. Chimney, he has also contributed extensively in the international trade and economic law. So these are few books which I have referred. So these are the classic textbook, these are the authors who generally write on international trade and economic law. So I suggest that please see that how exactly they have dealt with this particular subject. Further, official website of World Trade Organization. So official website of World Trade Organization is always updated, and they have included like GATT, its background. So everything you will find on the official website of World Trade Organization. So thus make it a habit to to visit these official websites, mainly of World Trade Organization. As also you please recommend your students as well that to refer these particular websites. On this particular website you will also find the cases decided by dispute settlement body, which is a dispute settlement body, it is a dispute settlement body of World Trade Organization. So you will you all will find the cases decided by dispute settlement body as well on the website of World Trade Organization. Okay, so this is how you may begin. Okay, like first of all you are required to see that how far your target group is aware about the basics of public international law. Then you please explore that how far they understand the trade and economics, its impact on market, as also consumers, as also individuals like you and me, as of course on the international relations as well. And then you please introduce them this literature to be used for international trade and economic law. And then after that, then we can start with our theoretical background and historical background of international trade and economic law. Even though international trade law and international economic law, these two subjects at times they connect with each other as per the syllabus, at times you will find that there are different syllabus, but then somehow theoretical and historical background is common to both of these subjects. Okay. The main theories which which we should refer, in fact not can, but we should refer, and those theories are mercantilist theory of trade, classical theory of trade, modern theory of trade, and new theories of trade. Plus the basic principles which are relevant for international trade law, they must also discuss in the initial classes, and they are like principles of like good faith, principle of non-discrimination. So these principles must also be discussed in the class. Historical background. Historical background, there are two options with you. Either you may start with a law of merchants. Okay, you can start with law of merchants, wherein people from one state, they used to visit to another state, they used to sell their products, and then in good faith they used to allow people from or merchants from other state to come to their own state, and those merchants they used to sell their products in their particular state. Okay, so this is how law of merchants it was developed. And in this law of merchant, no law was there, okay, no written agreement was there, but everything was depending on those practices which also took shape of a custom under international law. So from there you can start, or you may start with First World War, that because of the First World War and further because of the Second World War, how the industries, entire international market, how it got collapsed, and then how we realize that trade and economic relations are equally important as good as our political relations. International law earlier it was dominated by political relations, but today if you will ask anyone, we will accept that not only political relations but trade and economic relations are equally important. But this realization, this particular realization began with the world wars. After the First World War, again we wanted to regulate somehow political relations, but then again we witnessed the Second World War. So therefore, many thoughts had come and many people, they have given their suggestions also. And as you know, how United Nations organization was established after conducting or organizing various conferences, and so how United Nations organization came into existence. And we are also aware that in United Nations organization, in fact its preamble, it always speak about its own the main agenda, and their agenda is not only the states but also individuals. So United Nations organization, with its establishment, they recognize individual under international law, as also they recognize the importance of trade and economic relations as well. Now why? Because preamble of United Nations Charter starts with we the peoples of United Nations, and then further if you will see the objectives, then its objectives include the protection of fundamental freedoms of individuals, and its objective also include to develop trade and economic relations. Therefore, in United Nations you will find that along with General Assembly, Security Council, Economic and Social Council is also one of the main organ of United Nations organization. So ECOSOC, that is Economic and Social Council, it is mainly to promote, to develop the economic and social relations amongst the states. So this is the main objective, this is the main function of international of United Nations organization. Further, just before 1 year of the establishment of United Nations organization, we all know the Bretton Woods Conference, how International Monetary Fund and World Bank came into existence. So United Nations organization is 1 year younger than International Monetary Fund and World Bank. We all know the story of IMF and World Bank, that in that particular conference one more organization was about to came into existence, and that was International Trade Organization. But however, United States, they refused to accept the membership of International Trade Organization for its own reasons. If you will refer the literature, you will get that reason. And then other states, they felt that in League of Nations, United States was not there, and therefore, and that was the one of the reason that League of Nations got failed. Now again in International Trade Organization, if United States will not be there, then in that case, how will be the future of that particular organization? And as a result, that particular organization did not came into existence, but only International Monetary Fund and World Bank came into existence. With this, we started developing the international economic legal regime by the establishment of the IMF and World Bank. ITO didn't came into existence, but however, just before that, one conference held in Geneva, wherein one agreement was adopted, and that was in relation to General Agreement on Tariffs and Trade. So when in Bretton Woods Conference it was realized that we have nothing for trade, then they said that already that particular agreement is there, so let's continue that particular agreement, and that is what is General Agreements on Tariffs and Trade. So as IMF and World Bank, they are mainly responsible to develop international economic legal regime. GATT, that is General Agreement on Tariffs and Trade, is equally responsible and very essential element, important element to develop international trade law. So this is how we can say that international trade legal regime have been somehow started developing with the help of General Agreement on Tariffs and Trade. General Agreement on Tariffs and Trade started with around 50 members, and then further slowly and gradually many states they joined. In fact, they used to be called themselves not as members, because GATT is not an organization, it was not an organization, it was only an agreement. So we called it as contracting parties. if you will read John Jackson, then you will find very interesting fact over in that, and that is that contracting parties, when they found that even other states that they are also joining, then how to differentiate that we joined earlier and some of the other states they joined later on. So you will find that the states who were the contracting parties of GATT since the beginning, we write those in all caps, like all caps, contracting parties. But however, all the other states who joined GATT later on, there we use small letters like contracting parties, C capital and P capital. So all these things we are required to inform, we are required to tell our students. When they are reading, they must understand that why this contracting party is in all caps and this particular contracting party is in small letters. Okay, so there is a reason behind all these things. So I suggest that you please encourage your students to read thoroughly with all focus, and they should read seriously as well. Then only they will be able to get all these points which are very interesting in nature. In GATT, we are required to understand the various rounds as well. Now, what is round? So, every after 2 years, the contracting parties of GATT, they used to meet at some of the place, and therein they used to hold their own conference. So they called it as round table conference. Okay, so these round table conferences took place under GATT, and then in these particular round table conferences they used to decide, or they used to take some decisions to be implemented. In earlier 4 to 5 rounds, they discuss mainly that how to reduce the tariffs. Okay, how to reduce the tariffs or how to regulate the tariffs. So these kind of issues they discussed primarily. Then slowly and gradually they started discussion on various other aspects also. For example, textiles, for example, issue of dumping, right? So these kind of areas have also been discussed in GATT rounds. But in initial 4 to 5 rounds, in fact until Duncan round, you will find that only the tariff related issues they discussed. And then Uruguay round came. So just before Uruguay round, Tokyo round was there, and in Tokyo round, in fact with the Tokyo round, many developing states, they were not very happy with the development and the way they used to take decisions. So therefore for Uruguay round, for the next round, as such no developing countries and least developed countries were ready to join. But however, it was decided that once again we will initiate our talks, right, and we will discuss that how to go further. Some of the issues came before, like if there is a dispute, then how to settle, because in GATT only 2 provisions were there, and all contracting parties they found that those provisions are not sufficient. So that was one issue. Then another, United States, European Union, they wanted to have the agreements on investment, on services as well, and the developing states and least developed countries, they wanted to have agreements on agriculture. So there were various issues, but one thing is there, that as such there were less conflicting issues, but it's only that the developed states, mainly EU and the United States, they were having couple of issues. Other couple of issues we are having for developing states or least developed countries. So in a way, somehow in Uruguay round, with the help of the then Director General, they successfully, we can say that they come up with one decision, that let us have World Trade Organization. So this is how in 1994 World Trade Organization was established during Uruguay round. There are few more things, interesting things, which we must discuss in the class. So that particular thing we can discuss in our next part.